Well, hello. I think I know everyone, but I'll go ahead and introduce myself. I'm Jill Dupre, and I'm the Associate Director of Atlas and a member of the graduate faculty, which I'm happy about because it let me be one of Meg's co-advisors. This is the doctoral dissertation defense of Meg Ambrose. Meg has her J.D. from the University of Illinois College of Law, where she focused on digital music copyright and issues of network neutrality. During her time at CU, she has been a fellow with the Department of Computer Science on the eSite project, which is NSF funded. She also had recent fellowships at the Harvard Berkman Center for Internet and Society and Cable Labs. I'll also introduce Meg's committee members. Meg's advisor, Paul Ohm, Harry Surden, Susan Nebelow-Mart, Dick Green, John Bennett, and Diane Sieber. Also on her committee is Preston Padden, but he'll be watching electronically. Just to give you a sense for what will happen, Meg will talk for about 50 minutes. During that time, any of you are welcome to ask clarifying questions, but we ask that you hold any substantive questions. We'll have a time for public questions at the end. At some point, we'll ask you to excuse us, and the committee will deliberate on our own. So with that, Meg.
Yes. So I am really worn down with technology here. Something is definitely going to break. But I know everybody in this room pretty well, so I'm just going to say thank you to all of you directly. You all contributed to this work, and I really, really appreciate you getting me to this point. The dissertation is about digital oblivion. It's 300 pages or so. I am going to do my best to get this in around 50 minutes. I've had to reorganize some of the concepts. So if you've read the dissertation, this will look a little bit different. Come on, adjust. So here's an outline of the talk. I'm going to give a background on the issues that have led to the proposal of a right to be forgotten, go through some of the cultural and legal foundations in the US and the EU. Then I'm going to talk about the informatics of this issue and talk about just how permanent digital information really is and why that matters to the right to be forgotten. Then I'm going to go through the actual proposed legislation in great detail and try to clarify some of the concepts, and hopefully everybody will have a good grasp of what's actually on the table in both the US and the European Union. Then I'm going to talk about interoperability issues and how norms, technical systems, and law all sort of need to be coordinated for rights to be forgotten to be effective, and then talk about specific recommendations to the European Commission that's drafting the new right to be forgotten proposals. I'll wrap it up with conclusions and make some notes about future work. Noticeably missing from this presentation is alternatives to the right to be forgotten. They are included in part 4 of the dissertation, and I'm happy to talk about them during questions, but they're very time-consuming to present on. So as way of introduction, in November, the website Jezebel.com had discovered a number of racist tweets from high school students after President Obama was reelected. And the site pulled those tweets off and created these mock college applications. So they had the students tweet, the racist tweet with their picture and their name, and then information that was like Johnny plays baseball and is a, has a 3.6 GPA, and it was actual information that they found on the internet. So these racist tweets became very, very searchable under these students' names. People were really, really upset. It kind of felt like these adults were sort of bullying these kids. And Jezebel defended itself, saying that the First Amendment protects them from saying whatever they want, but it doesn't protect them from the consequences of that expression. And so the question for today is how long those consequences should last. And that is where the concept of digital oblivion comes in. Digital oblivion is meant to address these kinds of mistakes, not being held accountable for this type of incident forever. So some of these kids were 17, some of them were 18, some of the content that was posted was worse than others, and so trying to construct a legal concept, trying to construct a legal digital oblivion to handle this is really, really nuanced, and that's what we're going to see over the next few slides. I tackle this issue with an interdisciplinary approach. This is, of course, what we do in Atlas. The three areas are technical, social, and legal, and there's an international context to the work. When we started this project about 2 years ago, there were really only 2 pieces that had been written on it. Victor Mayer-Schonberger put this issue on the map with his book, Delete. It's still the most robust treatment of the subject. And in it, he concludes that we should all put expiration dates on the files that we distribute, and we can talk about how that's problematic. Franz Wero also did a comparative piece between the Swiss and US legal systems and their treatment of Oblivion, and concluded that the two just can't be reconciled. Jeffrey Rosen is one of the only US researchers to talk about this issue. He's been really, really critical of the right to be forgotten. He's a big First Amendment guy, but he did write this piece for the New York Times, "The Web Means the End of Forgetting," that's referenced quite often and is all about the issues that the right to be forgotten is meant to alleviate. So with all of these increases in storage, access, and retrieval, I analyzed the subject using this method that I borrowed from cybernetics. This is how Robert Weiner considered whether you should automate factories or not. So identify the problems and opportunities from the innovation, apply existing principles. If the existing principles don't fit, clarify ambiguities. If the resulting framework still doesn't fit, come up with something new built on ethical principles, and then apply the principles. So using that method and a lot of legal analysis and research from other disciplines, these are the contributions that the dissertation makes. It offers an alternative concept of the right, one of forgiveness, which is the value that we're going to be talking about, second chances, reinvention, and situates this within the US legal framework, clarifies the digital right as it's proposed, analyzes the digital information landscape, addresses the freedom of expression as a co-regulation tool, and proposes an internationally interoperable solution. So, going to give a bunch of examples here. We can reference these, the Jezebel example, and then the reel that was going before. There should be a lot of examples in your head now to look at this issue of digital oblivion. All of these are embarrassing, negative things that the subject would probably like to be disassociated with. They deserve varying levels of sympathy. So Ghislain Raza is a Star Wars kid. In 2003, he recorded himself in his gymnasium reenacting a Jedi scene, and some classmates found it. They posted it online. It's a huge internet sensation. I'm pretty sure everyone in this room has seen the Star Wars kid. Less well known probably is Caitlin Davis. She is the blonde posing next to the drunk passed out girl. She was fired as a Patriots cheerleader when this picture was found on someone else's Facebook page. And if you look really closely, you don't want to look too closely at this girl, but there's a swastika on her. And so Caitlin is posing next to this girl. There's very little context about what was going on here, what was found on someone else's Facebook page, but nonetheless, she was immediately released as a cheerleader. This is Alexandra Wallace. She posted a YouTube video of herself making racist complaints about her UCLA classmates. Another huge internet sensation, definitely not as big as the Star Wars kid, but there were a lot of remixes done of this video, and it spurred a really big debate about the university's ability to monitor and regulate student speech online and off campus. Then over here we have John Venables and Robert Thompson. They viciously murdered a 2-year-old in 1992 and became the youngest individuals in UK history to be convicted of murder. When they were released from juvenile incarceration relatively recently, they were given completely new identities, new geographies, legal oblivion. So the paradox here is that in a digital age, the only individuals that were given oblivion were the ones that committed the most heinous social offense. So it may actually be easier for Venables to get a job than Alexander Wallace because of this massive amount of information that's accessible. So this is a very large chunk of the dissertation. This is where we really look at this value of forgiveness and reinvention. And after looking at a giant body of forgiveness research from everything from neuroscience to UN findings from their research in volatile regions, we see that forgiveness is generally really, really good for us as long as it's done correctly. The Mayo Clinic, for example, finds that you actually have health benefits. You have, lower, all the things that come from lower stress, less rage, decreased risks of substance abuse, depression, lower blood pressure. All of these things come from forgiveness. Then what we did was we looked at every single forgiveness law that we could think of. And they are listed here, all of these criminal procedures, bankruptcy, so we have financial forgiveness, Fair Credit Reporting Act. And then we took the elements from them to build what you would consider a digital forgiveness law under a US framework. So if the US wanted to make a forgiveness law, it should include these elements based on the other forgiveness laws that it has on the books. And those elements are a forgivable offense. Some things are not forgivable in all of these laws. Some things just aren't going to qualify. A specific harm to the wrongdoer for not being forgiven. A social benefit to forgiving wrongdoers. We see this in bankruptcy generally, at least here in the US, we think bankruptcy is a good social thing to have. An element of time, and this is where we see accountability, rehabilitation, probation, and oversight from a judge or agency to make this determination of a relief of accountability. So relief of accountability in statute of limitations, for instance, after a year or two, you generally can't be sued in civil court or charged with a crime. Fair Credit Reporting Act has a general 7-year, after 7 years you can't use information, that's 7 years old after the Fair Credit Reporting Act, in the Fair Credit Reporting Act. So this is a foundation in the US. From an international perspective, there is a lot more specific right to be forgotten history. It has analog roots in countries like Germany and Switzerland that focus on criminal rehabilitation. So the right to be forgotten in these countries it allows an individual to prevent someone else from referencing them in relation to their criminal past. So if I've committed a crime, once I have been sentenced, I can prevent someone else, like a newspaper, from referencing me in relation to that crime. As a very recent and digital example of this, this is Worrell and Laubert. They were convicted of murdering a famous actor in 1990, and when they were released from prison in 2010, they sought legal action against a number of websites that had covered, I thought that was me, that covered the story and were still online, or had covered them being released from prison. And the way that this shook out in the German legal system was really, really confusing because it was based on how the content was presented to the user. So they had the right to be forgotten for some websites depending on how the user perceived the information, but not on others. They also tried to send a cease and desist letter to the English Wikipedia, which sort of got laughed at, and it was kind of like, bring it on. And they didn't. They did not bring it on. I don't think they wanted to set the precedent for that in the US. In 2010, France started a legislative initiative that was a self-regulatory sign-on. So they asked companies to sign on to this digital oblivion document that said they would these companies and their third parties would delete information after a certain amount of time or if the user requested. It did not get very far when Google and Facebook both declined to be a part of it, and we haven't really heard much about it since. We have heard a lot about the Spanish Data Protection Agency, who ordered Google to remove URLs from its index for individuals that it determined had a right to be forgotten. So these Spanish citizens go to the Data Protection Agency, they say, hey, I have a right to be forgotten on this issue. It keeps popping up on Google. The agency determines, yes, you do meet that standard, and then they ordered Google to remove these. Google challenged only 6 of these. There was over 100 of them. They challenged over 6 of them. They then took it to court. Google took it to court, challenged it, and both what we would consider the district and appellate level. And then once it was kicked up to the highest court, they asked the European Court of Justice to hear it. So we will get a really great sense of what the right to be forgotten means in Europe, but not for about another year when the European Court of Justice hears these claims from Google. I also want to mention FIPS, which is the Fair Information Practices Principles. These are international standards. They were developed in the 70s. They're in almost every single data protection regulation in the world in some form or another. All of them include this transparency, access, and accuracy. So a data controller should be transparent about what they do with data. They should allow for access, and they should keep information accurate. Some of them also include data minimization, and data minimization states that a data controller should only collect what it needs for a specific purpose, and when that purpose is met, it should delete the information. Data minimization is not in a lot of US FIPS, so I also want to mention, before I get to this last part, the right to be forgotten exists in Latin America as well, in a few Latin American countries. It's pocketed more in their defamation law. I don't talk about it in the dissertation. The dissertation really focuses on this tension between the US and the European Union as it's drafting its new regulations, which brings us to that new regulation. The European Union is redrafting its 95 Data Protection Directive with what's called the EU Data Protection Regulation. So the 95 version is called the directive, the draft version is called the regulation. In Article 17, they explicitly include a right to be forgotten, and the US, I don't think, really knows what to do with itself. So, background established. Now I want to talk about accurately discussing this information landscape. So up to this point, everybody that's really analyzed this issue consistently talks about the impact of this permanent record that we all have. And when we look not even that closely at digital information, you can see that it's a very, very ephemeral medium. And so when we talk about it in terms of permanence, we're really misstating the problem that the right to be forgotten is trying to address. And so that's what we're going to look at next. Another giant section of this dissertation is a sketch of an information life cycle. So I decided, okay, it's not permanent. How can we think about it? It's very long. It's very complicated. So my main goal over the next few slides is just to convince you that digital information is not actually permanent. And then I'm going to very briefly go over what the information life cycle looks like in the paper. So this is a laundry list of reasons why digital information disappears: media and hardware errors, software evolutions, natural disasters, internal and external security hacks, and economic and organizational failures. I would say this is the one that we're most familiar with. As an example, I was on Canadian public radio talking about Postulus, which is apparently really used in Canada, and it just was removed. It got bought by Twitter, and Twitter just decided to put it down. So all of that content was just completely lost. So if you had bad content on Postulus, it was a really good day to celebrate. And for everyone else, I think it was sort of, oh, I guess I'll move to Blogger. But most of that content has completely disappeared. And if we think about our own information uses, at least for me, I delete information off the internet all the time. I have deleted social media accounts. I have deleted at least 2 blogs. I delete pictures all the time. I delete tweets when I misspell things. And then we have things like eBay goods that have sort of a natural, they're removed from the site because they're disruptive to the service. So we also have things like Kayla Laws, which is a little bit closer to the examples that we were talking about before. Kayla found herself on a revenge porn site. The most famous revenge porn site is anyoneUp.com. Revenge porn is when your ex takes scandalous, I'll use scandalous is the nicest word I can think of, images of you after you break up, and post them on a revenge porn site, usually with your name, a lot of times phone numbers, address, parents' names, employers are included in these. They are readily searchable, and they are definitely the worst place to find your picture on the internet. So Kayla goes on Nightline as a victim of isanyoneup.com and is talking about how horrible these sites are. So a few newspapers online covered her coming out on Nightline. So there are a few articles about her coming out as a victim. Then last April, so a year ago, the site goes down and all of the content is lost. So the only reason, so I was digging around desperately trying to find someone that I could use as an example of revenge porn, but all of this content was gone except this reference from Kayla. So if you search her, you don't see any of this isanyoneup.com content from Kayla. You see nice pictures like this and a handful of articles about her coming out on Nightline. So everybody else, this is probably bad social policy, because everyone else who didn't stand up for themselves against this, it can breathe easy. So this is an example of how legal intervention isn't necessary for forgetting in the age that we live in today. So this is a compilation of the handful of persistence research that's been done to this point, and I think it is fairly surprising. We have these studies that were done from 2000 to 2003, and we have rates of 100%. After 100 days, only about 50% of content is there. Some of these studies are finding that we only have 75% of content after a few months. And then Gomez and Silva did this 3-year study, so it was the longest study that was done from 2003 to 2006. And they actually found decay rates that were faster than the studies that were done from 2000 to 2003. So they're saying, we really think that information is less permanent than it even was 3 years ago. And maybe that makes sense as we're getting, it does, I feel like personally my attention span gets shorter every year that the internet exists. So we have this 10 to 15% is pretty static for all the studies though. So after a year, we find 10 to 15% of content is pretty static. So what I wanted to know was, based on Gomez and Silva's projections, when would the information that they collected in 2003, so they used a crawler, they went out and crawled and they wanted to see how long they could access this content and how it changed. So I wanted to know when all of that content that they're in their original pot would take to be completely gone. And so if you take this and you project it out, it's about 8.5 years. So we have no idea if all of the content that we can see now on the internet is going to be gone in 8.5 years. I guess intuitively it seems like 10% of it should be static. But what's really interesting, I think, is that it's not the content that we find most valuable. So .gov sites have some of the worst decay rates on the web. So this is government information that we have a right to as citizens is most likely to disappear. Whereas blogs that are less savory make up maybe some of this 10% because somebody has really dedicated their lives to this subject. All right. Okay, so hopefully I've convinced you that information is not permanent. We need a different way to think about it if we're going to come up with a law that addresses the long-term effects of information. And the permanent record is not going to work. So we tried to come up with an information life cycle. And I did this based on these kind of factors that happen to information out over time. So we have a significant decrease in interest, a decrease of use, content stales, we're just not interested in talking about it that much anymore. It becomes less accurate as the world changes and the information stays the same. So it becomes less reliable. I know that the crisis informatics team often talks about retweeting and how you can't tell where the original source comes from. And it also loses context. A lot of times things on the internet aren't dated, or we lose information that surrounded an event and we can't really tell what happened. And as an example of this, these are the Google Trends searches for Caitlin Davis and Alexandra Wallace. Caitlin has this spike at the end of 2008 and then really no interest at all. Alexandra Wallace, same thing in 2011, and then nothing. And I think that this is me searching them over and over again, which is going to be important in the next slide. But I want you to compare this sort of decline of information value for the general population with the effects on the subject, which either remain constant or can accumulate and become worse. So based on how this information changes, and information is really just information because we use it, and so we divided all of the uses of information on the planet into two. There are immediate information uses and remote information uses. Immediate uses are those that we need to make an immediate decision about the state of the world currently as it is. So, is it raining outside? Because I want to know if I need my umbrella. Remote uses are the work that's done to uncover previously unknown insight into the future or past. So this is social scientists work, predictive analytics, historical work. These users want everything. They want a huge wide net, but they want accurate information, and they also rely on context. Immediate information needs, though, really suffer as information ages. So an example of this, if you're going camping and you want to know how many wolves are in North America, in the region that you're going to, you probably don't go to an encyclopedia because it's old, it's outdated. You would go to Wikipedia because it's more likely to be accurate and up to date. Your immediate decision is how many bullets you want to take because you want one for every wolf. Like you need an accurate number, yeah. However, for remote needs, you want to know exactly how many wolves there were every day, for as long as you can, to figure out the waves, the trends, the anomalies in the wolf population. So we have both of these needs. They're both really important. The immediate information needs really serves a general population, while remote information needs are more of a smaller, skilled researcher use. So then what we did, based on these needs, I assigned phases to information. Distribution phase, record phase, exploration phase. At the distribution phase, that's where we see that big peak in the Google Trend search. We have a ton of use, information is more relevant, it's contextualized, it's more, I don't want to say it's super accurate. I think everybody in this room hears accurate in the internet and their ears kind of burn. It's more accurate. And then it moves into the record phase where you're not really sure how accurate it is. You're not really sure if you can rely on it. Is it really up to date? As it loses that context, it's really hard to know how reliable the information is. And then at the exploration phase, this is when the information just no longer matches the state of the world. So it's completely inaccurate. Over here, though, information can become more reliable over time, because for a lot of these researchers, it takes time to see that something's interesting. So at the distribution phase, it's hard to tell if something should be collected unless it's already part of your project. But after a few years, you can say, oh, that's actually really interesting. I want a huge, huge sample of that information. So we have both of these uses. I'm going to apply this to Alexandra Wallace as quickly as I can. So let's say in 10 years, a PR firm really wants to hire Alexandra Wallace, but they have a super strict diversity policy. They don't want to hire somebody that's going to possibly make these racist comments. the company sees the information. Let's assume that this Alexander Wallace story defies the laws of informatics that I presented earlier, and it lasts 10 years. If the company relies on that information that has now expired because it no longer represents Alexander Wallace, we're going to assume that Alexander Wallace is no longer a racist in 10 years, then that's detrimental to their decision, right? They really want her, she's the best person, they're relying on bad information. But if someone is studying how race was communicated in 2010, they really want that information, and they want all the context. They want to know what year it was in. They probably want to know that she made a public apology and had to drop out of school. But that part of the context was really only covered by 2 small campus newspapers. And so if they lose their resources, that context is lost. So this is a conversation, I think, that's really about preservation ethics and establishing where we find information valuable and what we can really let go of.
Okay.
Yes.
So if it was Anthony Weiner instead of Alexander Wallace, would you just restart the immediate info need distribution phase when you ran for mayor?
Yes, exactly. So that is revitalized interest. So the comment is always, what if Alexander decides to run for president? Then we start talking about this again, right? So then the information starts again. So it starts up at the distribution phase again, and then will work its way back down the cycle. So if this video about Alexander Wallace, she's a public figure, we just keep talking about her, it'll stay in the distribution phase. It remains reliable, especially when oftentimes we see people continuing to make racist comments. And so we have this freshness, and this context helps us to tell that the information is still in the distribution phase. But it's also a good reason why we don't necessarily want to delete things forever. We want to preserve them so that if it's true, we can bump it straight back up to the distribution phase. It can have a ton of peak interest and go through its natural life cycle again. Okay. Now I'm going to talk about the proposed regulations. As we just saw, the information life cycle is very, very nuanced. But as we're going to see, the proposed regulation is not nuanced. So we have some changes that I would like to make. This is the actual language proposed by the European Union. This is going into effect. I am also going to talk about the US bill that's proposed here. It is not likely to pass. And so after I discuss the US version, I'm going to really focus in on this European language. So the European Commission drafted this. It requires a data controller to delete information when a data subject requests it, if the information is no longer necessary for the purpose that it was collected, if the subject withdraws their consent, or if the subject just generally objects to the further processing of their data. And this sounds like this has to do with cookies and data trails and being able to force Facebook and Google to delete your click stream. But as we see in paragraph 2, we really are talking about public information. Paragraph 2 has to do with procedures for data controllers that have made information public and their obligation to reach out to any third parties that have made that information public. So there's a lot of obligations on the data controller here. Of course, there are exceptions. The exceptions are very generic: freedom of expression, public safety and public health, historical, statistical, and scientific research purposes. The interpretation of this is incredibly important. I think here the exceptions make the rule. So you could arguably keep absolutely anything for historical and statistical purposes. So this is really vague because the way this works is the European Commission says, hey, European member countries, you need to make laws that enact this. So all of the European Union countries will establish a right to be forgotten under their own legal background. And it has to adhere to this. But the reason that this is so vague is that's just sort of how the system works. The European Union gives their member countries some flexibility here. So every country is going to interpret all of these differently. In the US, Ed Markey has proposed an eraser button for kids under 18. It's in the Do Not Track Kids Act, which would amend the Children's Online Privacy Protection Act. Again, it is not likely to pass, but the language is really interesting. It requires the operator of a website or online service, online app, or mobile app, to the extent technologically feasible, to implement mechanisms that permit a user of any of these services to erase or otherwise eliminate content that's made publicly available. So this is a total reaction to kids do stupid things and now it's on the internet. So for everybody under 18, you can just force the operator to erase the information that you put up there. Okay, so all of this information is very vague, it's very confusing. It seems like it's hard to really understand what exactly they're trying to reach. I don't know the answers to that, but I have established this matrix to try to sort this out and make the decisions about application a little bit easier. So I use Twitter as an example to help explain this. So we have internal content, that's content that derives from me, internal information, so information that derives from me. It can either be data, which is passively created, so that's as you surf, how long you stay on a page, your connections to people. I'm calling it your click stream here. It's collected usually through cookies, beacons, other things. Then I have the content that I actively create. So I actively and intentionally put up pictures, I tweet things, and if that content remains on the initial site, so here the initial site is Twitter, I still have some control over it. But when that is retweeted, or when Twitter sells my clickstream to a company like Axiom or another data broker, we say it's moved downstream. And so we have a significant loss of control from here to here. Someone else can also tweet things about me or put up other information about me. And so that is considered content that's externally created. Once that's retweeted or pulled onto someone's Twitter feed on a website, it's considered to be downstream. So we have content that's created by me, content that's created about me by someone else. It can be passively created, actively created. It can be on the initial site, or it can move downstream. And so that's why this column is empty, because someone else can't passively create information about you. So we have 6 options here that we could say the right to be forgotten. This is what we want the right to be forgotten to be. We could say that we just really think it's data. It should never really affect this, because here the content slides we're talking about expression. This is just not something we want to mess with. Or we could say this is really only workable for the initial site. Trying to get all of these third parties and downstream entities to delete information is just not workable. We could also say, nope, this doesn't cover anything anyone else says about you. But right now, the European Commission says, the way that the language works, it says, yep, this covers everything, and we're going to treat it all the exact same way. And so I want to reference the information lifecycle and talk about how data held by data brokers and by these companies will naturally have a much longer life cycle than content that relies on public interest. So we have very different life cycles happening, and the subjects of these are going to be very different, which is going to affect their life cycle. And so to treat this all the exact same way is, I think, really dangerous, particularly because the interest in content is so much broader than the interest in data. When you talk about data, there's probably a handful of companies that are contracting it, so that's who we're messing with when we say you can delete that data. When we talk about content, we're talking about all of those immediate and remote uses. And so in this paper, the right to be forgotten across the pond, that's what's really emphasized, is that data and content are very different, and they should be treated procedurally different. So briefly, I'm going to go through interoperability issues. These are found throughout the dissertation. I'm going to start with norms and social interoperability, go through technical problems that need to be resolved, and then finally spend more time on legal interoperability. So one thing that is really important to remember with the right to be forgotten we're talking about completely deleting information, deleting the digital version of that information. And that really freaks people out because of pictures like this. That is just not old enough for us to not be, to not cringe when we think about deleting information. We could have a more measured response to the right to be forgotten. We could limit access, we could limit use. That's something that the US does a lot. You can't use certain information in employment decisions, for instance. Those, of course, are really hard to enforce. And we have some problems when we talk about limiting access, notably from the security arena, where the security teams love data minimization. That is absolutely the best form of security. And so limiting access is really, as we'll see in the next slide, we have some technical problems with that. But for this slide, what I want to mention is we don't know how to make these decisions. As data controllers, we don't know when to delete, when to limit access, and when to limit use. And I talked about this with the European Commission in Italy in November, but establishing principles based on information stewardship, and that is that value, who is using your information? I went through all of the things that I just delete willy-nilly. I'm a horrible information steward, apparently. So we're not really thinking about the potential uses of the information that I posted. I just wanted to delete it, so I did. And that is bad. But we do need to establish some way of determining when it's best to delete, when it's best to limit access, and when it's best to limit use. We also have some technical problems. I want to mention that forgetting is always going to mean limiting access in some form, because we can't delete everything everywhere. This is not about paper records. This is not about memories. This is not about going into people's old computers. This is about information that is accessible and adding hurdles back into the retrieval process. So the great thing about digital content is it has a bunch of different access points that you can play with. So you could anonymize the information. Paul can talk to you about just how impossible that is. But things like the Jezebel site, you could say, well, let's remove these kids' names so it's not, so it doesn't come up on Google. Of course, you can still figure out that it's that kid through a million different ways, but it just adds a hurdle back into that search process. Facial recognition, there's software that does the same thing, that can mess with a image so that facial recognition doesn't catch it. Also, if a name or an image is really important to content, you can add a robots.txt file so that an ethical crawler, which the ones that we use are ethical crawlers, doesn't crawl it. So it's not in the index. So it's still there, it remains there, and it almost turns the entry into like a card catalog search. So if you know the subject, you can dig through and find it, but you can't find it through a Google search. This all sounds very good until you really look at the Star Wars Kid Wikipedia page. So Wikipedia uses this policy, the Biography of Living Persons policy. And they basically say you shouldn't add a person's name into an entry, a private living person's name into an entry, if the entry is really just about an event and the name doesn't add any value to it. So it's this great concept. I love it for information stewardship principles, but so Ghislaine Ross is not in the Star Wars Kid entry, and there was this whole conversation, why isn't this kid named in here? But when you search Ghislaine Ross's name on Google, the Star Wars Kid Wikipedia page is the first thing that pops up. So this technical connection still needs to be resolved, even if we figure out the norms and the policies that we want to put in place. Okay, so a little bit more time on legal interoperability. This is the last two parts of the dissertation. The entire world cares about the way the right to be forgotten shakes out for a number of reasons. We all use the content on the internet, so removal of it is detrimental to all users that could have possibly used that piece of content. It may be a very small number, but it does impact us. Also, a large number of companies and data controllers that are going to have to comply with this come from the US. As you can see with this giant traffic image here. So US companies certainly care about their obligations under the right to be forgotten. Also, systems aren't generally designed in a country-specific way. So when we design a system that allows for easy deletion, it's not only going to be European citizens that are deleting content from those spaces. So the way that the 95 directive handled this was they established a safe harbor for the US. US companies would sign a letter saying that they did these 7 things. They were doing these 7 things, and then they would file that letter with the Department of Commerce. It wasn't really hardcore enforcement, but that was the way that they decided to handle it. Vivian Redding, who is heading up the European Commission and drafting up this new proposal, has made it very clear that she is cracking down on US companies with this, so the safe harbor very well may not make it into the new regulations. And so we're not exactly sure how US companies and data controllers are going to react to this, but let me just walk through how this would work. This is a user-initiated removal system. And so if you're familiar with the Digital Millennium Copyright Act, it has a user-initiated removal system. I guess it would be an owner-initiated removal system. And the way that these work is a user contacts the operator and says, remove this because of my legal right. And the companies in the US do so to relieve themselves of liability. So in this right to be forgotten regulation, the way this would work would be, let's say you have a Spanish woman and she wants to remove something from Twitter. So she sends a right to be forgotten request to Spain and says, I want you to remove this because I object to it. Twitter has to first authenticate that the woman is who she says she is, then establish that she is from a European Union country, and then figure out how Spain's non-existent jurisprudence on the right to be forgotten should guide its removal of this content. So it just puts a huge amount of, it just puts a lot on the data controller here. And we're going to talk more about non-EU, called them stakeholders, non-EU countries and countries like the US that have an interest in the right to be forgotten. This is what they could do right now. So they could either copy and paste the right to be forgotten from the EU. They could just say, sure, we'll just adopt the same thing because it's efficient and easier if we all have the same rules. They could just ignore all right to be forgotten requests and say, no, we have the First Amendment and you can't make us do this. They could just roll over and say, okay, we get rights to be forgotten requests and we'll just delete the information. Or they could meet in the middle. This is obviously where I'm going, and so I'll talk about that at the end. Copy and paste really doesn't work for us. I talked a little bit about how we could kind of berry pick legal concepts from forgiveness laws in the US. We are not there yet, certainly. It's just not practical to do. We just don't have the cultural and legal foundation to immediately put a right to be forgotten in place that mirrors the European Union's. Ignoring it, ignoring a right to be forgotten request might be practical for some people, but not likely for the companies that we're really talking about. A lot of them have offices in the European Union, and the way that Europe handles jurisdiction is different than the US. And they do have, basically, if they have an enforcement mechanism that works against you, you really can't ignore it. The fines for violating this regulation are incredibly steep. And in the new regulation, it says that you have to follow the rules if you use any European Union means to access the data. So basically, if you use the structure in Europe to collect European data, it's virtually impossible to not fall into European Union jurisdiction on this. Also, I should mention, companies really do like to comply, just in general, with international laws and all laws everywhere. And as far as the US goes, they want to cooperate with Europe. They have other interests that they need their cooperation with legally. Rolling over and just taking the right to be forgotten requests and adhering to them also has problems. We learned this from the DMCA. I mentioned it briefly just a second ago, but the DMCA takedown notices have been heavily abused, not only by copyright owners, but throughout other industries. We see a massive amount of abusive removals. We have authentication problems and just general errors. So when data controllers, well, when copyright owners contact these platforms, they really just remove the content immediately because it's really hard to figure out if it's fair use, if it's anything else. They just pull it down so that they don't get in trouble. And I think that it's very likely we would see the same thing because of the problems that I mentioned before in the Twitter example, guessing how Italy feels about the right to be forgotten. At least with the Copyright Act, we have a body of law that you could look at. These are principles that aren't even established in these countries. So people are just going to remove content. Yes, okay. My idea here is that we stick to a traditional approach for Oblivion, which is a concept that I associate with the public content. So those content columns, I think that we should say, you need a court order to remove this stuff. That's what we do now. If you go to Google's transparency report, you can see all of the responses that they've made to things like defamation claims. They don't meet our First Amendment standards at all, and Google still, it doesn't have to do anything. It just has to respond to a legitimate court order based on a judge's interpretation within that country. It can operate like that. It's not a super smooth system, but they do have policy teams in place. Operators know how to react to these. I think that we also should probably accept the takedown system for the data columns. I don't think that Europe is going to really bend on this. And I think that we should look at it as a user participation tool in data minimization. So we have this data minimization on the books in a lot of places. This really just allows a user to enforce the data minimization principle on their own behalf. And if we look at it that way, I think it makes us cringe less. I actually dislike the data minimization principle, but I think that conceding on that point makes sense from an internationally interoperable standpoint. Okay, conclusions. So those are the immediate responses, immediate changes I would make. Long-term recommendations, these are, I've sort of alluded to these in the talk. They're spelled out in the dissertation. This recommendation is sort of a desperate cry for research from information science on web ephemerality. Give us a better sense of what we are looking at here. Does information last over 5 years? If it doesn't, do we even need a right to be forgotten? Is 5 years a good number to say we should all have to live with things that we put online? We need conceptual refinement. This is when I was talking about the data versus content, dividing those two up and really making sure we consider public users other than the data controller. This is a huge theme in the dissertation, time. There is no time in any of this. So we talk about forgetting, which in our lives takes time. There's an element of time. It's in US forgiveness laws. I really like it. I like the accountability aspect of it. I like the rehabilitation. It allows us to address whether information is still valuable after a certain amount of time, as opposed to whether it will be valuable in the future. And so we're missing this on the European side, but in the US there are conversations for the Children's Act that when it's not for all children, but either after a certain amount of time or when you turn 18, you sort of get this clean slate when you turn 18. Lastly, information stewardship, I briefly alluded to, and again, this is just recommending a principle that we all think of ourselves as information stewards of this space and consider how not only the information that we distribute online, I think we're really good at that. How does the information we distribute affect other people, but also the deletion of information affect other people? These are the hard conclusions. The right to be forgotten addresses a valuable social interest of second chances and forgiveness. It alters an information life cycle, not a permanent record. There are alternatives to the right that need to be combined for it to be effective. Deleting privately held information should be treated differently than erasing publicly available content, and non-EU entities should work for a more traditional approach when they're talking about publicly available information. These are the chapters that make up the dissertation. They have all been published with the exception of Speaking of Forgetting, which has just been accepted to TPRC 2013, so I'll be presenting that chapter in September. And this is a few of the presentations that I have given on this. Jill and I presented at South by Southwest, best presentation ever. And I was in Italy in November talking to the European Commission Joint Research staff about ethical implications of the right to be forgotten. Future work, I mentioned these, web ephemerality. There is somewhat of a debate about the First Amendment based on Neil Richards' paper talking about data as commercial speech, which gets less protection and complicates those nuances that I was talking about even more. We have a lot of international jurisdiction and enforcement things to still work out. This is the next project that I'm going to be working on, how children are particularly vulnerable of harms and perceived harms. If you saw in the slideshow, there's a shot of Amanda Todd, who was 15 and committed suicide after these images of her got out and she was bullied for them. And there's this horrible shot where she's holding this picture that says, or this piece of paper that just reads, "I can never get that picture back." And so the perception of kids that they will have to live with this forever, at least in that case, and I think in a lot of cyberbullying cases, can have huge consequences. As long as I pass this defense, I will be teaching at Georgetown in August, and these are the classes that I will be teaching there. And that's it.